So students, now I'm back with the most important segment, that is the difference between the original MTP Act and the new amended MTP Act, which is still not enforced up till now, but it's there, already passed by the Lok Sabha and the Rajya Sabha, that I discussed in my previous segment. Also, for the students who have subscribed to my classes, I have included a copy each of the original MTP Act and this gazette, that is the newer amended MTP Act. So you will find it in the notes. Once you've subscribed to my classes, the detailed notes regarding the procedures of the MTP, the certain legal stuff which is supposed to be followed when you're doing a medical termination of pregnancy, the complications which includes everything right from septic abortion, septicemia, to all the procedures, including the brand names, the doses, everything is included in the notes for the students who've already there subscribed with me. And right now I'm discussing the most important thing on the choice of and on the queries of all of you students who are approaching me. A lot of you have a doubt in the differences and what exactly are we supposed to write in the examination, the difference between MTP, the original MTP Act, and the amended MTP Act. So I've tried to tabulate it for you to make it easy to understand. But since this is the language of law, so you have to once at least go through these two acts, which are I've not tried to go for a very longer version. I've just included the excerpt which you are supposed to read in the notes. So definitely go through it. Now let's start with what is the difference between the original MTP Act and the MTP Amendment Act. Now, the original MTP Act, like the lecture I spoke about before, is basically a very rigid act. They just say that the termination is allowed only till 20 weeks of gestation, whatever be it. Whatever be it. But in a society like ours, where before marriage, sex is considered a taboo, rape victims, they are shamed, incest definitely looked frowned upon, such females find it very difficult to step foot and accept and own their pregnancy, as a result of which usually the diagnosis takes that particular amount of time at which the pregnancy starts to show, and that is usually after 20 weeks. So to safeguard those women, to give them once a chance of safe and legal abortions, this MTP Amendment Act has also been incorporated, and the differences is right here. First of all, the termination in original MTP Act was allowed only till 20 weeks. But in case of MTP Amendment Act, 24 weeks gestational age, we can go. But only in certain conditions. This is upon the registered medical practitioner. Before I go in further, let me here discuss the second point as well. The first point was that termination over here only was allowed till 20 weeks. But in this case, you will see two things. One, that gestational age has been increased to 24 weeks, but only in certain conditions that I'll describe to you later, because those certain conditions have to be discussed. And second thing, there is no upper limit for substantial fetal abnormalities as diagnosed by medical board. These two things have to be kept in mind. That means I am talking about no cutoff of 20 weeks as a must. It can go in for the complete pregnancy also, but provided it has been diagnosed as an abnormality of substantial, fetal risks. So now I'm talking to the second point. Registered medical practitioners, in case of, the MTP Original Act, only one RMP was required till 12 weeks, but you needed two RMPs, registered medical practitioner. If you want to know the definition of registered medical practitioner, that also is very important. It is there in Indian Medical Council Act of 1956. But I'm sure you've already known, anybody who's registered with the state or central, government medical council is a registered medical practitioner, and you get this RMP or you get this registration immediately after your undergraduate course. But that does not necessarily mean your MBBS course. Many other, para MBBS courses also are registered. But in that case, the other, conditions have to be fulfilled, that you should have assisted or performed at least 25 MTPs yourself. And of course, anybody who's having a certificate of obstetrics and gynecology, be it a degree or diploma, is definitely an RMP. So that was in a nutshell about RMP. So at least 2 RMPs were required above 12 weeks until 20 weeks. In this case, it is the other way around. You need 1 RMP till 20 weeks, but above 20 weeks, at least 2 RMPs are required. Now, why are these registered medical practitioners required? What is their say? You are an RMP, so if a patient comes to you, what is your responsibility? If she comes to you at 22 weeks with some fetal abnormality, for example, let's say Down syndrome, okay, she's still in this limit. But if she comes to you with Down syndrome at, let's say, 28 weeks, what will you do? Or let's say 26 weeks. Let's not go into the a week of fetal viability. Let's talk about 26 weeks. What will you do? Is it an abnormality of substantial fetal? Is it a substantial fetal abnormality? An abnormality which the fetus might not survive if it is born? The baby will survive with Down syndrome. So is it a serious substantial fetal abnormality? Well, that will be decided by the medical board. So you will have to refer to the medical board. But if a patient comes to you with Down syndrome at 22 weeks, will you go ahead and abort that child? Yes, you will, because it is why is it in your hand? And now I'll read this particular line. Why? Because I'm trying to tell you what makes you decide whether this pregnancy should be going ahead with the abortion or not. I'll tell you. So, like I said, these 2 points, I hope the points are absolutely clear, that the gestational age has been raised from 20 weeks in this 24 weeks for certain conditions like rape, incest, and fetal abnormality, and any time in pregnancy for substantial fetal risks. That means probably those abnormalities which are incompatible with life. But there are so many that has to be decided by the medical board. But now I'm telling you what is the responsibility of an RMP. Subject to provision of subsection 4, a pregnancy may be terminated by a registered medical practitioner in continuance of the opinion formed in good faith, where the continuance of pregnancy would involve a risk to the life of the woman. Either the pregnancy, you will terminate the pregnancy on only 2 grounds: whether it is harmful to the mother or whether it is harmful to the baby. The continuance of the pregnancy, right? So first thing, that is harmful to the mother does not only include the life risk to the mother, but also grave injury to her physical or mental health. That means all rape victims, incest victims, handicapped victims, minor victims who did not know the nature of the offense that was being done to them come under this particular category. They have themselves explained it. Like, see, this is written in the book of law. I'm not giving you an explanation myself. Like I said, that a lot of information gets lost in translation. What I'm doing right now is translating it to you. But right now, what I'm doing is reading exactly the language of law. Explanation 1. For the purpose of this clause that I just described, where any pregnancy occurs as a result of as a result of failure of any device or method used by any woman or her partner for the purpose of limiting the number of children, the anguish caused by such pregnancy may be presumed to constitute a grave injury. That means very clearly they have given, for the purpose of clause A, the clause A includes only pregnancy till 20 weeks. Now this is the difference. When I was talking about gestational age increased to 24 weeks, well, the gestational age has not been increased to 24 weeks if in case there was a contraceptive barrier breakdown. That means I'm still talking about gestational age less than or equivalent to 20 weeks for contraceptive failure. So the certain other conditions for which this thing has been raised is basically rape, incest, and fetal abnormalities. Explanation 2. For the purpose of clauses A and B, that means I'm talking about 20 weeks and more than 20 weeks, where any pregnancy is alleged by the pregnant woman to have been caused by rape, the anguish caused by the pregnancy would be presumed to constitute a grave injury to the mental health of the pregnant woman. That means it's for us to decide, the registered medical practitioner is going to decide whether this particular pregnancy continuation will bring in any kind of risk to the life of the female or any mental or physical trauma which can be accounted to grave injury to the woman. And the second point is, there is substantial risk that if the child is born, it would suffer from any serious physical or mental abnormality. So if the child is born with any physical or serious physical or mental abnormality, you are in your way authorized to perform or to go ahead and suggest her a medical termination of pregnancy. Of course, a lot of ethics are not performed in smaller cities, but when you know you are performing anything which is directly under the scan of law, you have to be very, very careful. So in a nutshell, what I'm trying to tell you is that the difference between the original act and the MTP Amendment Act is that the gestational age definitely has been raised to 24 weeks, but for certain conditions in which the contraceptive barrier break or a failure of contraceptive device does not come till the in order to increase it to 24 weeks. It still remains at 20 weeks. I just read it directly from the law. Now, second, when I talk about no upper limit for substantial fetal abnormalities as diagnosed by medical board. So once you have this doubt that this abnormality, she's come at 24 weeks or let's say 25 weeks to you, and the abnormality that she presents to you like fetal abnormality, which you're not able to understand whether you should go ahead and schedule an abortion or suggest her an MTP. In that case, you just call for a medical board. The medical board decides, and the medical board includes a gynecologist, a pediatrician, a radiologist, and one member from the state government, from the government actually. Now, these were 2 points that I discussed about. I spoke about the termination age and about the registered medical practitioners. How much do you need it earlier? How many do you need now? Now I'll talk about the fact that the lady can come with her husband. The lady earlier on, when we spoke about the contraceptive barrier break or a failure of contraceptive device, the use of husband was there. The term of husband was there. That means if and only if she's having a pregnancy which is under the bounds of socialistic norms, that means it is within the boundary of marriage, can she go ahead and schedule a medical termination of pregnancy under the law. But even now, in case of MTP Amendment Act, even the partner word has been put as substituted against the husband word. So that means if there is a contraceptive failure between two partners, that includes all partners, she can still go ahead and go for MTP. Now the third, 1, 2, 3, 4, and I'm talking about the fifth point. Privacy of the female, the one who has come and scheduled an abortion, is very, very important. So all the forms that you'll fill, you obviously, if you working in a government institute or a legal private institute, you must be filling in form C, form 1, and form 3 is submitted to the chief medical officer after every month to tell them that how many abortions have you done, how many of them are first trimester, how many of them are second trimester, what was the reason for doing abortion and stuff like that. So basically what you do is you submit these reports every month. That has to be very, very private, the details of which have not to be disclosed to anybody until and unless it is for legal reasons, and to be usually submitted in the law firm or under the court of law. So you have to keep the privacy. It has to be sealed, the number has to be written, the name has not to be written. So these were the salient points of differences between what original act was and what the new Amendment Act was. If still you have some doubt, feel free to approach me. I'll include all these points in my notes, which I'll be providing to my students in my classes, and of course the other details are already there with you. So just stay tuned and read up this yourself so that you're able to understand it better.